pardon to mention, Your Lordship, one fresh writ appeal matter, Your Lordship.
Please give a slip.
Your Lordship.
My lord, fresh PIL matter.
Please give PIL.
My lord.
What
Yes,
is that?
encroachment of government land
Encroachment of government land.
Yes.
Why have you come here?
to evict the
Evict, there is
encroacher.
provision for eviction.
Yes.
You could have.
I have also,
Give a slip.
my lord.
That's unnecessary PILs.
My lord, pardon to make a mention, my lord. Fresh admission writ matter, my lord. Fresh
Give a slip. Have you mentioned urgency in your slip?
Yes, my lord. Mention.
Please give yours.
I may be pardoned to mention, Your Lordship, this matter was today listed before Honorable Justice S.K. Panigrahi. Since this matter is not assigned to him, he has directed to be listed before any other bench. Then, so since I couldn't make it out where it will be listed, I inquired in the list section. That will be listed before Honorable Justice K.R. Mahhotra. I mentioned it right now, but he is not inclined to.
No, he
take
should
this-
have, rightly he declined. The
Yes.
the matter will come to me in my chambers, I'll assign.
The Lordship, the urgency in the matter is day after tomorrow, the learned tribunal has granted as a matter of last chance to hear this matter. It's the matter of 2016. And
Give your slip.
obliged.
Take care of that. Oh, file no order.
This admission item number 1.
Yes, my lord. The delay has been condoned. Matter related to rehabilitation appointment. Death occurred in 2015. Then the present respondent, she made her application 2 years thereafter to be considered under the rehabilitation assistant rule. Then her application, then after commencement of the new rule in 2020, her application was considered and rejected on the ground that under the new rules, there is no provision to consider the application of the teachers of the aided educational institution, because the rule is basically framed only in respect of the state government employees. That was rejected. That rejection order was challenged in the writ petition in 2023, my lord. The Honorable Court, my lord, the Lordship may kindly see, only directed, that is at page 53. Page 53, the Honorable Court directed to consider the representation of the petitioner so and so. Although there was an order of rejection, and the order of rejection that your Lordship will find, that is at page annexure 6 to the writ
Then
petition.
why should we interfere? You can take a decision.
But a decision already taken, she is not eligible, and that order she challenged in the writ petition. That order was never set aside.
That was never set aside. You can say that in your order. That the order is still there. Order has not been set aside. You can reiterate what you have mentioned, but why should we interfere?
Mr. Satpathy, there's an order to consider her representation.
My lord, that consideration, in fact, in the writ petition, he challenged the order of rejection of her case. That is at annexure 6, your Lordship may kindly see the
It was
order.
already rejected.
Already rejected. And only ground is delay. Delay that death occurred in 15. She made application in 17, but approached court in 2023.
Sure, but the court has this record that.
That too without expressing any opinion on merits or going into the merits.
We will also not express any opinion. We
Lordship,
will also not express, we will mention that the order of rejection has not been interfered with.
my lord, Lordship, with that grant liberty to consider.
That's the order. That is the order.
That is the order.
In fact, there is no observation at all. There is no observation at all. Only representation is pending, may be taken.
The state of Odisha has put to challenge an order dated 27/4/2023 passed by a single judge of this court in WPC number 12970 of 2023. Order dated is it? 12970 of 2023, whereby the learned single judge has directed the appellant to take a decision on a representation which was filed on behalf of, filed by the respondent in relation to his appointment on, her appointment,
Her
appointment on compassionate ground. Under what do you call rehabilitation scheme?
Orissa Civil Service Rehabilitation Appointment Rule 1990.
It is next, it is submitted on behalf of the appellant that the respondent's case, or call it rehabilitation appointment.
My lord.
Yes.
Rehabilitation assistant.
Assistance.
Appointment on compassionate ground.
Rehabilitation assistance.
Can't be called rehabilitation appointment, appointment.
Rehabilitation assistance.
Here was considered for appointment on compassionate grounds under the rules consequent upon the death rules on an application made by her in that regard, consequent upon the death of
The death of her husband.
her husband. The respondent was working as, respondent's husband was working as teacher in an unaided school when he died.
Unaided or aided school?
Non-government
That's
aided school.
Non-government aided school.
Right.
Non-government aided school
The time it is dead.
at the time of his death. Stop. He submits that the order of rejection has not been interfered with by the learned single judge. First off, however, the appellants have been asked to consider the representation filed by the petitioner. First off, next, considering the nature of the order which has been passed by the learned single judge, we are not inclined to interfere in the present intra-court appeal. First off, there is an innocuous direction to consider the representation which the respondent had filed after a rejection of her claim.
Yes.
To consider, to take a decision on the petitioner, on the respondent's representation. Filed after rejection of her claim for appointment on compensatory ground. Stop. Learned counsel for the appellant is right in his submission that the order rejecting the respondent's claim for appointment on compassionate basis has not been has already been has not been interfered with. Stop. Accordingly, we do not find any merit in this application and this appeal, considering the nature of the order passed by the learned single, impugned order passed by the learned single judge, this appeal is dismissed, but with the aforesaid observation. Yes.
Item number 2.
Only if my lords indicate that we may
Take a decision.
fresh
There is
decision.
nothing, Mr. There is nothing. Wait a minute.
Because there's a reference to the Malayalam Seti.
Malayalam set in the prayer, not in the.
It's not in the order.
Yes.
Item 2.
May I please? My lord, the appellant herein had assailed order dated 22/4/2024. The relevant portion of which is at page 62, my lord. Here actually the matter was remitted back. Now in view of the document brought in by way of the additional affidavit, my lord, there has been consideration of the representation matter, and now there are observations for which I may not have to press this appeal, my lord.
Don't press.
My lord.
And counsel for the appellant, after some arguments, seeks permission to withdraw this appeal. This appeal is accordingly dismissed as withdrawn.
My appearance may be noted for OP
Please.
number 7.
Please give.
Item number 3.
May I please? That's it. This is the second round of journey.
Journey,
Yes, Lordship.
why?
Lordship, earlier, Lordship,
What happened in the first round?
Lordship was given some liberty to the prisoner,
Yes.
and that liberty was not complied by the opposite party
Why
corporation.
did you take that liberty? Where is that liberty?
Lordship, that is.
Where is that liberty?
Lordship. Lordship, kindly come to page 8.
8.
Lordship.
So you have quoted the order.
Lordship, that is quoted, Lordship.
Yes.
Para 15. Learned counsel appearing on behalf of the petitioner after some arguments seeks permission to withdraw this writ petition with a liberty to approach the Indian Oil Corporation Limited for reconstitution of the partnership in accordance with the new policy of the corporation effective from 25/9.
So forget this was nothing. No liberty.
That's it. Then kindly come to next paragraph.
Yes.
When we raise that objection, they may take up this liberty as mandated by this honorable court. Lordship again passed an order that is at para 3. We see no reason why the corporation shall not consider the petitioner case in accordance with its own policy. Accordingly, this writ petition disposed of. Thereafter, I formed the new partnership firm that is white. Annexure 8, Lordship. That is at page 77. This, Lordship,
Then what happened?
that was not considered till then. They are sitting over the matter. I have constituted one new partnership firm, and as per their policy and as per this honorable court's order, observation, but that was not considered by them till then.
For what?
For I am the stockist of Sorbo one lubricant. I am the stockist, and since 2003 I am the stockist, engaged as stockist. But in 2023 they just appointed another one, citing the reason that one of the partners' age is beyond 70 years. So I am not. I am failed to adhere to the policy, that condition. That I challenged before this honorable court. That this policy, this age is to be beyond 70 years. That is contradictory to Partnership Act. Lordship observed that, no, you, as per their policy, you comply that. So I reconstituted my firm with
No, but in the meanwhile, they have already given that to someone else. No.
in the meantime, after this disposal of this writ petition, they appointed another one.
Then how are they compelled to give you agency or whatever.
But Lordship, my standing was sub judice before this honorable court. Lordship, as per
Mr.
policy,
Counsel, please
I may be.
business dealings. Sorry. No further liberty.
Liberty was granted, Lordship.
It was already granted.
And I had that suspicion, Lordship, while passing this on a court order, that I raised that also.
Sorry. Pointed.
That I don't know. Actually, they may be issue notice, Lordship, so that they will answer
So
that.
we will issue notice to A or Z.
No, Lordship, issue notice to the corporation.
Corporation, and then the corporation will tell that
Who will be.
beyond your knowledge.
Have
Then
you
don't
stated
do your
anywhere?
knowledge.
Have you stated anywhere that somebody has been appointed? Or that also you are just stating like that? Which paragraph have you stated?
Lordship, kindly come to para 19, Lordship. Page 10.
What is this annexure 7? What is annexure 7?
6-7 is that is the email letter given by them.
That is the advertisement,
Lordship.
appointment.
Lordship.
Pursuant to that, people must have applied, they have appointed.
What is the date of advertisement?
Advertisement date was 19/10/2023.
What can be done?
1910 or 2910?
Lordship. Before the date of appointment, I came before this honorable court.
So you want us to issue a direction that they should consider your representation, no?
Lordship.
That we will not do. We will decide your right this way or that way.
Lordship, Lordship may kindly issue a notice to them so that
No, sorry.
they'll come before this honorable court and file their counter. Everything will be clear, Lordship.
No. This writ petition has been filed seeking direction to the opposite party number.
Sole opposite party, right?
Sole opposite party.
So Indian Oil Corporation to reappoint the petitioner's firm as servo stockist auto for the districts of Ganjam, Gajpati and Kandamal, in the light of this court's order dated 7/3/2024, passed in WPC number 41232 of 2023. Oh, stop. Next. It appears that the petitioner had earlier approached this court by filing a writ petition giving rise to so and so. As on the so and so, since on the ground that one of the partners of the firm had crossed 70 years of age, comma, the partnership, his partnership to the reconstitution shall not be accepted for the purpose of reappointment of the firm as servo stockist auto. It is called stockist auto.
Lordship.
Oh, stop. Next. The said writ petition was disposed of with the following observation. Disposed of as withdrawn with the following observation by an order dated 7/3/2024. Stop. Learned counsel appearing on behalf of the petitioner has submitted that the firm has been reconstituted complying with the new policy of the corporation, complying with the policy of the corporation, and an application has been made for the to the corporation for reappointment. Stop. When did you make the application?
12/3/2024, Lordship.
On 12/3/2024. Stop. However,
Just, sorry. The deed of partnership is 12/3, but your request is 27/3.
Sorry, madam. 27/3/2024.
27/3. (2024), but the opposite party has not taken any decision so far in that regard. So stop. Next. It, however, appears from the pleadings on record that where is Annexure 7? What is Annexure 7?
That advertisement which says
That for the said stockist auto, the Indian Oil Corporation had come out with an advertisement in 2023 itself.
29/10/2020.
When on 29/10/2023. Stop. Learned counsel for the petitioner has submitted that he does not have any knowledge as to whether any stockist auto has been appointed or not pursuant to the said notice dated 29/10/2023. Stop. It is, however, an admitted position that the petitioner had, you have not filed that the petitioner had not responded to the said observation, said advertisement.
No, earlier writ petition was filed challenging that advertisement. Earlier writ petition.
You had been in,
I had challenged that order.
Said advertisement, and he had rather challenged the advertisement in the earlier writ petition, that is WPC number so. Stop. Next, learned counsel for the petitioner has not been able to establish that the petitioner has or had at any point of time to be reappointed as stockist auto, despite the qualification which it suffered under the policy of the corporation of the opposite parties / Indian Oil Corporation. Stop. We do not find any reason to interfere in the matter. Stop. This writ petition is accordingly dismissed. Yes.
Item number 4.
Your Lordship, we filed the counter affidavit today, Your Lordship.
What is this about?
It's about, Your Lordship, he's claiming some funds for a documentary film that he produced without permission of the opposite party number.
What is VAW? What is VAW?
Mr. Naik,
Yes, madam.
what is VAW?
EAW, I can.
Don't know. You are appearing in person.
Yes, sir.
Who drafted your petition?
Myself, I drafted.
Huh?
I drafted.
Therefore, we are asking this, what is VAW? Because you have written.
Rules plus, sir.
What is this?
Yeah. Oh, sorry. Sorry. What is your case number?
They have given instead of 24. Ask them to give 24. Must be there on record.
What is your case number?
182852 by 2024.
All right, it will come later. Wrong file is there. Huh? What's it?
Where are you coming from?
I am from Cuttack.
Cuttack only.
Monday.
Counter you give him a
I'm
copy?
copying.
You are filing your counter in 2023 or?
No, Your Lordship, today only we filed a counter.
Fine.
Case number is 24.
A
182.
copy of the counter affidavit has been served upon the petitioner in person by Learned AGA representing the opposite parties. Stop. Let this matter on. When do you want?
Next week, sir. Next week.
Next week. On next week. What is your dispute?
Actually, sir, opposite party issued one supply order to make documentary film. My quotation was for pre-production, production, and post-production. After getting the supply order, my production already started because in supply order, they mentioned clearly, you are directed to production the documentary film. That's why I started the production. Once I started the production, one of it will be finished also finished, and I submitted the documentary film at their office. But they denied, they are telling that this script is not approved. They are telling me.
I told him, but you must write in the supply order the approval of script. You will make the picture. But in supply order, they clearly instruction for production of documentary film. If not production, then EMD will be forfeited and you will be blacklisted. In clearly, that's why I make this picture.
All
Sir.
Item number 5.
Sir.
My lords, on behalf of my senior, I'm praying for an adjournment as is out of station. Like,
why, sir? Out of session.
yes, my lords.
Listed on mention.
Yes, my lords. That's why I'm praying for for your lordship's discretion to let the matter come tomorrow or day after tomorrow.
Is there any urgency? And how to do it?
Yes, my lord. This is a tender matter, my lord. The tender has been cancelled, and the petitioner was the sole bidder in that, and he had won it.
Item 5.
Item 5.
5.
5 is
Amya Kumar Jain.
what?
That also is something wrong or what?
Yes, my file is something.
Oh, what is this? 163 item?
5.
No, 18309. All right. No, that is all right. The one. 18309. 18309 you don't have?
No, my
We can adjourn the matter, but it will not come tomorrow. It will come after 2 weeks. But why did you make a mention for urgent hearing?
My lords, there's also an IA to post.
Oh, there is an IA you mentioned, but how could you leave if there is urgency? And he's a senior counsel. Any other counsel can also do it.
This case has been listed at the top on a mention having been made for urgent hearing. Top learned counsel appearing on behalf of the petitioner seeks adjournment. Top list this matter after 4. It appears that the petitioner that there is no urgency in the matter. Top list this matter on 4 weeks.
Item number 6.
Wait, please, minutes. Let's say tender was floated by the opposite party, WACOS, which is a PSU. Minutes. If your lordship will kindly come to page 11 of the petition. Minutes.
Yes.
Page 11, Minutes, will see this is the tender document for construction of integrated infrastructure complex in Bolangir district. Minutes, will kindly come to page 15.
Yes, what is the mandatory additional qualification?
Milats, yes, that is the issue here, Milats. If your lordship will kindly see page 28, which is that mandatory additional qualification, Milats, is directly against the CVC circular. That is my endeavor to establish before your lordship. Milats will see para 6, point number.
Whether CVC circulars are binding?
Plus, this CBC circular is binding on the departments.
Yes, whether CVC circulars are binding.
On the departments, yes.
How?
Because it is for the departments only, because to ensure that transparency is there.
So this has been issued by which body?
This is a PSU. This is under Ministry of Jal Shakti.
All right.
Government of India.
Yes, let us see.
Now, let's will kindly see point number 6, Milats, at page 28.
Yes, no. So tell us how CVC instructions are binding.
Well, let's will see. If your lordship will kindly see the CVC guideline at page 300.
No, how are they binding?
That's
how do you say that additional condition cannot be imposed?
Yes, plus,
beyond what is there in the CVC guidelines.
Yes, plus what CVC guidelines? Plus, yes, there has to be a fairness in the bidding process.
Forget.
And for
see, Mr. Counsel, you are relying on CVC guidelines as if they are statutory provisions. Maybe it may be the policy of this public sector undertaking that they will strictly follow the CVC guidelines. They cannot deviate. So either there is any provision, any policy decision of PSU that they will not deviate from, CVC guidelines, even in the matter of putting additional qualification, or if there is any decision of any court on this point, that the CVC guidelines are to be strictly followed, literally followed.
Yes.
Whether additional conditions cannot be added, how do you say that?
Well, for that, if I may kindly take your lordships to that circular itself. Your lordships, as your lordships knows that there is in the case of Varsha Plastics judgment, I'll produce those judgments are there of Supreme Court, which says the circulars are binding on the officials of the department, binding on the departments, may not be binding on the courts, cannot be binding on the courts.
See, does the CVC guideline say that no additional qualification can be imposed? What is there in the CVC guidelines, that those guidelines have to be followed. All right. Whether the CVC guidelines say that beyond this no additional condition can be put.
Because that is something your lordships can examine.
Depends on the nature of the work.
Yes,
which is to be executed.
That is what I'm.
And this is
that while framing the pre-qualification criteria, end purpose of doing so should be kept in view. So,
well, let's hear what happens.
guidelines.
This CVC guidelines, why it came into picture for the first time, that is also laid down.
Maybe it's an additional qualification for some purpose.
Yes,
for execution of this thing, a particular nature of work.
Precisely.
And this is the employer's choice. It is not that.
I completely bow down to that observation of your lordship. But what I intend to say is, these additional qualifications can be in the nature of what that is there in the CVC guidelines.
Yes.
It says definition of similar work should be clearly defined. So similar work is defined at page 28 of the brief. It is defined in the contract. Then it says, in addition to above, that is the criteria, that is the mandatory criteria. In addition to above, the criteria.
We are reading which?
I'm reading the page 300, 300. First, if your lordship, since your lordship are at page 300, where the circular starts, we'll see the first para. The commission has received complete.
No, forget that. Where is that? What?
Sorry, Milad?
Additional qualification.
Yes, Milad. We'll see the next page, 301, point number 5. If lordship has point number 5.
Yes.
A, Roman 2. This is the experience that a person must have. Experience of having successfully completed similar works during the last 7 years ending such a last day of month previous to the one in which applications are invited should be either of the following. 3 similar completed work costing lot less than the amount equal to 40% of the estimated cost. These are the criteria which are mandatory in nature. Now, additional criteria, what can be an additional criteria? That is under Roman 3. Definition of similar work should be clearly defined. In addition to above, that is the additional criteria. The criteria regarding satisfactory performance of works, personnel, establishment, plant, equipment, etc. may be incorporated according to the requirement of the project. My humble submission is this, what can be an additional criteria is relating to satisfactory performance, relating to personnel, relating to
performance of work also.
Yes, performance of work. What performance of works, personnel, establishment, and what plant equipment you have. But what is the additional criteria here? Additional criteria is something that goes tangent to what the essential work is about. This is a building contract. Earthwork that is involved in this contract, which is 52.6 crores is the contract work. The earthwork involved is only 1.8 crores. And for that, what the criteria says that you have to have an experience of earthwork of 10 crore in a single project, which is completely not related to this. That is my humble submission. So and your lordship will come to page 29 of the brief. At the top, similar work has been defined.
29.
29, my lord.
29, it's just first page of that bid.
29, running page 29, my lord. At the top.
Bid identification.
Two.
Just a minute, let me see. Am I having the wrong brief? No, this is it. Oh, sorry. I've opened the wrong one.
My lord.
29.
At the top, it starts with a quote. Similar work refers to, what is similar work? Construction of residential, non-residential building having RCC frame structure, infrastructure development project for any central government, state government, PSU department. Plus, this is the type of work that falls under similar work. Now, Malad's earthwork is something that is completely tangent. And for that, what is the mandatory additional criteria that is kept? If your lordship will see the previous page that is there, it says additional qualifying at the bottom, Malad's, in the previous page, the agency should have completed earthwork as a prime contractor of value amount.
Where are you reading?
Plus page 28. Just the previous page at the bottom, Millets. So my humble submission, it keeps the competition out. The person who are actually involved in construction of buildings, they are not at all related to earthwork. And this imposition of condition, it keeps competition out, the eligible people out of the competition.
No,
that is my humble submission.
No question of-
You cannot say that they don't have. Some may be having that experience.
Yes, I cannot say that. But my humble submission is
this exercise is not only for generating competition, it is also for the purpose of execution of work.
precisely. I bow down.
So if you have to have some employee or something to be done in your house, you will try to find out as to who has the
I
best
completely
experience.
I completely
that-
bow. I bow down to you.
Applies.
Bloods, I know, I know the challenge before your lordships is quite uphill. But Bloods, here your lordships will only visualize from the ambit of Bloods that circular that clearly says it has to be related. My humble submission, it is not at all related.
All right.
So
Let us
that
see what is
Does your work not involve any earthwork?
it involves, Bloods, that's what I was saying.
What?
Work in the contract value is 52.6 crores. Out of that, earthwork is only 3%, that is 1.8 crore. And for that, they want an experience of 10 crore in one single project.
just
Who is WAPCOs?
WAPCOS is Water and Power Consultancy Services. It is under the Ministry of Jal Shakti. It's a PSU. In fact, to be very honest, plus I also didn't know the full form till this scheme.
No, I was asking because what are they doing here in Orissa? That is why.
Yes, because they are carrying out this
Consult-
construction. It's a
there is no earthwork involved in this.
earthwork is a minuscule, only 1.8 crore.
What is the total value?
52.6 crore.
52.6 crore. What is the 10? What is 10% of 52?
10%.
3%. What is the
52.
earthwork?
What is the earthwork involved? 1.8 crore. Only.
So the agency should have completed earthwork as a prime contractor.
Yes, my
So
lord.
in addition to this, you should have experience of this also, 10 crore or above in a single project during last 5 years.
In
So
earthwork.
even one.
Single one.
Yes, my lords. In earthwork. Not in the main. I am not, my lords, I am not in quarrel with the above clause, the mandatory clauses, the standard clauses. I'm only in quarrel with this additional clause.
If we understand that. So according to you, what should have been the percentage?
Let's that is, my lords, is something
No,
what
no,
I am
you-
bringing to your lordship's
I think
notice
understand
is
that.
this
The
tender
extent.
clause.
We understand. So according to you, we are putting this question to you.
Well,
What should have been the student 2 crore?
Well, it's around the reason. Well, it's 1.8 crore is the earthwork. Your lordships could be similar to that.
We will not enter into that.
Well, my humble submission is, if your lordship will kindly
Are you
appreciate.
objecting for that qualification regarding earthwork completely or the value?
No, Millards, what I am saying, Millards, is this amount itself is disproportionate and completely unreasonable in the sense that for only a farthing of the contract value.
Then why are you interested? Do you have any experience?
Yes, Millards, I am because of this, Millards, this
Experience
clause.
in earthwork, do you have?
Yes, Millards, I have, but then not to that extent because I'm a contractor.
All right.
And earthwork, Millards, your lordships will kindly appreciate. Earthwork is only, it has got nothing to related to construction.
Oh.
Construction is completely different than earthwork. What?
We understand.
But you're saying this also involves earthwork?
It's a minuscule, only 3%.
Maybe, but
Maybe that is the
required.
foundation.
Yes, Millards, earthwork is only for extracting earth and using that in the construction. That's all.
That's all.
That's all is the
Digging-
involvement in
Digging
this.
is the only thing.
Yes, that is earthwork.
Very good. The construction has nothing to do with that.
No, Millards, for procuring that earth,
Yes.
it is only for that purpose. Because construction, your lordships will appreciate, Millards, that contractors who have experience in
All right. We
construction.
will decide it.
Very well. Lordship is
Monday.
public sector undertaking.
yes, ma'am. It's under Ministry of Jal Shakti. Ellipsis. Very well. Would your lordships consider Tuesday instead? Monday, there's some difficulty. I'm so grateful. Minus, grateful.
Item 7.
Well, that's the only thing I wanted to bring to your lordship's notice. There's another matter also in similar situation. Your lordships have issued.
We have issued notice.
Yes.
When is it posted?
Today.
Today.
It's
They've
there.
filed a counter.
Plus, I'm not aware. Milas. I'm not there.
Which is that item?
33.
That in
There also that it was CVC guidelines were there.
You sure? He's not the council.
Yes, Milas.
Not the council.
This is the order passed, Milas. It's just, your lordship have issued notice on.
Ms. Patnaik, item 33 counter is ready? Because we'd given you another chance on 12/8/2024 for the counter. Item 33, 16065.
It, Millards,
Challenging a
it-
clause.
yes, Millards, because Millards, again, there was also a flouting of the CVC circular, Millards, and your lordships.
We'll keep that in mind when we are taking up that matter.
My lords.
33.
Item number 7.
Obliged.
But this is a matter pertaining to a tender which has been floated by the East Coast Railway Lords. East Coast Railway is the Khurda division, road division, engineering of, this is a tender which has been floated by them. My lord, I'll just appreciate that's a condition which has been pertinent to this, which is at page 14. The tender notice. Lord, what had happened, Lord? I'm just coming back to your lords. This advertisement value which has been stated here is 1 crore 9 lakhs. I have an unsuccessful because on account of this. 1 crore 9 lakhs is the tender advertisement value. Now your lordship will just see that the person who has been scored, your lordship will just come to the next page 18, the criteria. Who has not been eligible, the person who has been selected, come to the eligibility criteria, which is at 18. Similar works means, my lord has got it, page 18. My lords, the similar work means execution of road works. My lord may just take a note of this cement concrete. What has to be specific about it? Now your lords will just come to that next standard technical criteria, which is just a bottom below. The technical eligibility criteria, may I just read it out. The tender must have successfully completed or substantially completed in any one of the following categories. Now the categories comes to number 3, third line. 1, 3 similar works, each costing not less than the amount equal to 30% of the advertisement value of the tender. 2 similar works, number 2, 2 similar works are each costing than the amount equal to 40% of the advertisement value of the tender. Third, my lord, the 1 similar work costing not less than the amount equal to 60% of that advertising value. Now here is the issue, my lord. I have qualified. My lord will just come to that page, number 24. This is a chart. This is the experience criteria which I have produced it. My lord, see the first line of that table. This is the cement concrete repaired to the internal road between godown number 1 to so and so by providing CC road, which is the cement concrete road at so and so road. Now your lordship will just come to that gross value of the executed work. The fourth column is of 88 lakhs, which is definitely falls under more than the 60% of that 60% of the value, which is an advertisement of tender, which is come to 60. I've got 88. Now what had happened? Then I got to know. Then this person has been selected. Then I've made a query under that RTI. Your lordship will come to that RTI application, which is at page 52. 53 is the reply. They have said the 52 is the advertisements that my applications to them when he came to know about this. Then, my lords, tender notice was issued to my lords then 13 to 20, 30, my lords. Date is my lord 13/12/2023.
Work duration is 6 months.
May I just let me just complete of my side. Notes. Now the page 54. The reply is really shocking. Lots will just come to that. The third says the total value of CC road, excluding RCC structure of retaining wall and culvert, which is of 54 lakhs, which is less than the what is the advertisement which has been originally condition which has been prescribed. Thereafter, they have just, I've asked them that give us the details. They have said that no, you can't give us the details. You come and inspect the file. What had happened now, they have issued the LOA. I am the basically really the success. This person has not been qualified. And they have given the bidding to him. And they have given the tender allocation to him and LOA has been issued.
When was that given?
February 2024. No, it's not yet started. That is what I said so in my. My lord, may come to the
Work
page 10.
duration is 6 months, my lord. Already lapsed 10 months only.
That's maybe. But work has been, my lord is pertinent to asking the question whether work has been started. I said so, page 10, my lord. I said the work has not been started. Lord, my difficulty, your lordship will has to look into it. When apparently there is an injustice. Illegality has been done. And which is they themselves admit that it is 54 lakhs. That's where my right has been curtailed as such. 54 lakhs they themselves admit. Well, if that's so, my lord, well, that has to be looked into, bronze. And the work has not been started as such. That's what the statement which I made at page 10.
Yes, sir. I agree to that.
My lord, the work duration is 6 months. Already 10 months already lapsed, my lord. We take instruction if I don't have no instruction.
You don't have instructions, it is written there. What is the tender for? What instructions? What is the work for? You don't know.
Road damage repairing, my lord.
Exactly.
The road has been repaired.
I have no instruction.
Rainy season, I doubt if it will be repaired.
File your affidavit.
Yes.
Lord, may I just say that in the public interest, I don't want any stay. If at all they are not working as per I made a statement on record. Lord, may I just say that let that be subject to having an early date and let that be subject to outcome of this. Because what had happened?
This is what the Supreme Court says.
Practically, apparently they themselves says that I am not saying anything which is on record. So that has to come on, my lord.
Yeah.
Have an early date, your lordship may look into it.
It will come.
Item number 8.
I may plead your lordship. Lordship, can we turn to page B to understand the case please? Convene to lordship page B of the writ application. Appendix 2B, that is called Appendix 2B. Date chart. Third page of the writ application, madam. The petition for lordship having completed +2 science and securing more than 90% marks appeared the NEET examination, which was held on 5/5/2024. When the result was published on 4/6/2024. NEET examination result was published in which petitioner was allotted the rank of 58,786. Then, my lord, on 26/7/2024, scorecard re-revised was published, upgrading the petitioner rank from 55,399 from 58,700 is now upgraded. Then 14/8/2024, rank and mark was available in those website, my lord. On 11/8/2024, our Odisha OJE declared eligible to the petitioner for counseling for 2024 for MBBS and BDS admission. On 14/8/2024, the rank and the percentile score of the petitioner was kept on hold in the light of ongoing investigation. 17/8/2024, OJE now says that you are not eligible. Last day is 7 and 8. I have appeared the computation. Let's see, can you turn to the
Last day.
like 7 and 8.
No, my lord.
September 7 and 8. September
Last date is October, my lord.
That I don't know. But
September.
that's my
October.
question.
Counseling schedule is with me, my
I do
lord.
not-
Last date is
OJE,
October.
OJE. You are speaking about OJE.
No, have you given the schedule of OJ?
Yes, sir.
Which page?
Let's see, kindly see. The first permission was granted by
NT.
my lord, page 16. Page 16. Odisha Joint Entrance Examination, my lord, page 16. Let's say, look at eligible status. Just above the paragraph 1. Eligibility status. MBBS, BDS, eligible for counseling. That was allowed. Then after, my lord, a communication was made by NET. Let's see, kindly see, my lord, page 17. That kept on hold in light of ongoing investigation. Then, my lord, the impugned order
Where?
is at page 19.
Annexure 17 kept on hold. Where is it?
Annexure 4, my
Sorry,
lord.
Annexure 4, page 17.
Page 17, let's say, look at
Yes.
total percentage score obtained in what's kept on hold in light of ongoing
So
investigation.
where is it written, kept on hold?
There's page 17, my lord. Annexure 4. Table number 2, my lord. Total NEET all India ranks. Against that, the total percentage score obtained in words
Yes, got it.
kept on hold. Yes, my lord. So I may be allowed to participate subject to final result.
No.
But I am not accused in any investigation in any form, my lord. Not only Odisha, I will be debarred throughout India to sit in the counseling. None fault of mine, my lord.
Oh, so
I've
that,
secured a score. Again, it was upgraded. Now they said it is on hold for investigation. Last day of state.
Where is that order which we are challenging?
I am challenging now the annexure, page 17, annexure 4. Read with, my lord, annexure 19.
page 19, not.
I'm sorry, page 19, my lord.
So annex,
What is the final decision?
No decision, nothing, sir. Last date is 7 and 8 so far Odisha is concerned.
No.
7 and 8. That is-
In this case, OJ is not.
How do
NTA
you
is.
say that you have been disqualified for all the examinations throughout the country?
Because, sir, if it is hold, there is the score is not given to me, marks is not given to me. How can I participate in counseling? I have to pass in the NEET, my lord, to participate in counseling throughout India.
Whether you have passed or not.
I have passed.
You had earlier passed.
I have, yes, first it was 58,000 some odd, so far my rank was there. Subsequently, it was 55. Then all of a sudden, and JE also allowed us to sit in the counseling.
You are right now.
I do not know, my lord. Last is 55,000, 55,000,
Okay.
500,
page 17, that is why that percentile score, they have left it blank
blank,
because of that.
because of that.
Uh-huh.
Let's say, look, annexure page 14, my lord. My last rank was, which was given. NEET, all India rank is 55,000, third line, my lord. Page 14, annexure 2.
They had given you percentile in that.
That second revised.
17, they have not given.
17, some days back after they saying the investigation going on, therefore,
Investigation.
we told the, because I cannot appear throughout the country.
That we understand that if you are not qualified, you cannot participate in council.
But it is not the case that I'm not qualified. It is on hold because of their investigation.
No, because of that only. So thereafter, they should have informed you either you have qualified or you are not eligible. Because
Nothing,
of
sir,
something
madam.
that
Nothing, sir.
left in the hanging like that.
Later.
You get this, which is at page 17.
Page
And where did
17,
you get it?
page
This
17
was
is what
communicated
we
to
get.
you or you just downloaded?
Download.
You must have downloaded. Because that must have been the case in in respect of every candidate.
Must have been when the apex court was considering.
Annexure 4, page 17. But the rank of the percentage score and the marks of the petitioner was kept on hold in light of ongoing
So
investigation.
therefore, when you were referring to page 17, whether this was communicated to you or it just downloaded.
I have downloaded.
So you must have just downloaded because when you downloaded the document, the investigation was going on. And therefore you got this information.
No, they have withheld it.
No, they had
Everyone's.
withheld it then. Thereafter, no communication.
No communication.
Have you attempted to now download?
Attended that to download, my instruction is no communication.
Instruction will not do. File an affidavit, we'll see.
All right, ma'am.
Because they keep updating. So now they might have posted the other marks now.
So that I do not know because no communication.
Nana Gala, how you have to check.
1 week time may be granted.
No,
so that
let
we
them do.
will take
My instruction is still today it is not uploaded. My marks, whether I have failed or passed, forget about the rank.
You file an affidavit first.
Yes, ma'am.
Tomorrow. Come with affidavit. We are adjourning for tomorrow. Admission matter.
You can also find out if you want what is there.
Item 9.
No, he'll have to look in. No one else can do it.
Pursuant to an tender notice. The e-tender was, online bid was invited. That is at Annexure 1, page 20, 14/3/2024. And the time has been extended by issuing the second corrigendum, which is at page 59 of the brief. The corrigendum provides the date and time for online receipt of bid has been extended 5:30 p.m. of 25/4/2024 instead of 5:30 25/4/2024.
Yeah.
And the bid document with requisite financial instrument to be received on or before 5:30 of 30th of April 2024. I submitted my bid, online bid, and they supplied the bid confirmation. I have annexed Annexure 1. On 26th, I submitted my original bid documents in their office. They advised the requirement of law is, advertisement is, you have to send the same through speed post or registered post. You have to send the same through registered post. Then on 29th, I sent the same through speed post from Kit Post Office, which is about 3 kilometer distance from the GM's office, place of destination. On 9th, they refused to receive and the mail was returned to me on 11th. After receiving the same on 11th, I again requested them, since I had offered you on 26th and you did not receive, and I sent it in due time on.
So you had attempted
on 29th.
On 26/4/2024.
24.
So why did you not send through speed post on the very same day, 26/4/2024?
That was late. The post office was closed and 17, 18 was holidays.
27, 28.
27 and 27 was holidays.
26 was closed.
20. I offered in the late hour on 26th. By that time, the post office was closed and 27 and 28 was holidays. Therefore, at the first hour of 29th, I posted at the Kit Post Office, which is at a distance of 3 kilometers.
What was the last date?
Last date was 30th. Last date was 30th. Then I made a representation to them along with a copy of the judgment of this Honorable Court, where the addressee has chosen a particular mode that it should be served through that mode. If it has been supplied in that mode before the date, then it has to be treated as if the article has been tendered. And after submitting that, your lordship, then again they return to me. The same thing again they return to me. And I filed a writ application before this honorable court. This honorable court, after hearing both the parties, directed the general manager OP number 3 to consider the representation in the light of the judgment passed by this honorable court, which is reported in 1989 Orissa page so and so, and passed that order. Without considering that, again under Annexure 8, they returned the same. The Annexure 8, your lordship may kindly. Before that, let me take your lordship to the order which has been passed by this honorable court. I have quoted the same at paragraph, page 10, paragraph 10. No. This is, your lordship remember that is the judgment passed by Honorable Justice R.C. Patnaik and Honorable Justice A.K. Padi. In the year 1989, some colleges, and that judgment I have annexed to this. Your lordship, page 11, paragraph 4. In course of hearing, learned counsel for the petitioner states that highlighting its grievance, the petitioner has made a representation to opposite part number 3 by the Annexure 5 series, and the same may be directed to consider taking into consideration the judgment of this court in the case of Dr.
No, where is the requirement that it should be received through speed post on a particular date?
Page 59, corrigendum 2.
Or addendum 2?
Page 59. The last date time online received bid has been extended to so and so instead of so and so. Bid document with requisite financial instrument to be received on or before 9:30 p.m. of 30th of 4/20 by speed post and a registered post, and bid shall be opened on so and so.
This should be or, man. This should be or.
And till date, the financial bid has not been opened. Recently, they have opened the technical bid of other bidders. No financial bid has yet been opened.
No, but please come to the original first.
My lord. Original is at clause 3 and 7 of the original bid.
Yes.
Page 20. Bids, clause 3. I have submitted.
7.
Relevant is 7, man.
3 and 7.
Clause 7.
Oblige.
So see, online,
My
the
lord.
last date was
25th. Was 25th 4.
Was 25/4.
I have submitted, they have supplied the bid confirmation report to me. There is no dispute.
It was
Online. Online submission is in order. That is not questioned by the opposite party.
Here you're saying
Only this
25/4.
the original
I'm saying 2/4. Not 20. First was 2/4.
My lord.
And on 2/4, by 2/4 itself, the physical copy was also required to be served?
Yes.
On same day?
No.
Where-
On the next date, by 30th. In the first requirement, first I will submit my bid in the online. After the original document has to be supplied to them in a subsequent day.
How do you say subsequent?
Here it has been mentioned.
Where?
Your lordship, let me place clause 3 first.
Yes.
The bid shall be received online on or before 5:30 of 2/4/2024.
Yes.
Bidder must possess the compatible digit so and so so and so. The bid received on online opened on so and so. The profit of the general manager, it is not relevant.
No, just a minute. No, just a minute. So, all right. T you have read?
Yes,
Now come to 7.
7. After the date and time of receipt of the bid is over, that means the online bid is over.
Yes.
The bidder must submit the original MF certificate, demand draft towards cost of bid documents and TDR, NSC, BG towards the original bid security EMD from any nationalized scheduled bank shall be placed in favor of the Capital Region Urban Transport in the office of the General Manager, CRUT, Bhubaneswar, in a sealed envelope to be received before 2/4/2024.
Same day.
Next day, that is the same day. And then please look at the last line.
Speed post, registered post, that is in the original, that was the same day. My lord, this has been extended by corrigendum 2.
So they all right. Let us come to corrigendum 2.
My lord. Before that, should I place corrigendum 1? There is 2 corrigendum.
No. See, your contention is
Corrigendum 2.
dates for online and the physical, they are different.
2 different dates.
2 different dates.
My lord.
In the original advertisement, the date is same.
Same.
So what is the corrigendum?
Yes.
First corrigendum.
First corrigendum is with reference to the bid identification number so tender of construction number so, this is the nature of work. The last date, the relevant portion I am placing. The last date time for online receipt of bid has been extended up to 5:30 of 15/4/2024 instead of 2/4/2024. Bid document with requisite financial instrument to be received on or before 5:30 p.m. of 19/4/2024 by speed post, registered post. Bid shall open on so and so. Here the distinction first comes 15/4 and 19/4.
Right. There is difference.
Yes.
Now let us come to the second corrigendum.
Second corrigendum. The same, the nature of work has been mentioned. The last date and time for online receipt of bid has been extended up to 5:30 of 25/4/2024 instead of 5:30 of 15/24. Bid document with requisite financial instrument to be received on or before 5:30 of 30/4/2024 by speed post. Therefore, there is 2 dates. Or online bid must be submitted by 25th and the original document must be received by 30th.
Yes.
My lord, this is a Capital Region Urban Transport, my lord.
Take notice.
Only I am appearing for the state, my lord, Energy Department. Energy Department has no rule.
Yes, so notice.
Okay.
One week. 4 weeks. Sir.
Can I pray? Okay.
May I please, Lordship? My Lord, the petitioner is a student and appeared in the NEET UG examination 2023 and scored
2023 examination.
My Lord.
So what can be done now?
My Lord, he was provisionally, he was allotted to take admission in Sri College of
Nothing can be done now, Mr. Counsel. This session is over.
No, my Lord. First year session is not yet completed, my Lord. My Lord, kindly see Annex 4. OJ provisionally allotted seat in Sri College of Ayurvedic Science and Research Hospital, Orilo, Cuttack.
You want admission?
No, I have already taken admission.
Then?
And I have prosecuting studies.
Now the OJ not approving my admission on the ground that kindly see Annexure 12. My lord, at page 31, not as I have not withdrawn from the counseling process till third round. They are saying I have got allotment through OJE counseling and not withdrawn from the counseling process till third round. That's why they are not approving my admission.
Why are they not approving your admission?
They are saying in the subsequent round, you have not withdrawn from the counseling process.
After taking admission?
My lord.
If you participate in the counseling thereafter?
No.
Who is the concerned?
We have been served a copy, Your Lordship. Your Lordship may kindly permit me a week's time for instructions.
List this matter on 1 week, retaining its position, so as to enable learned counsel for
Opposite party number 4, Your Lordship, the OJ.
opposite party number 4 to seek instructions and file affidavit if so required.
My lords, here the petitioners participated, applied in a tender process advertised by the opposite party. 1. And may I pray lordship to have a glance at page number 8.
Page number 8.
8.
Yes.
That the technical bid was opened on 9/7/24. The petitioner submitted all the 10 requisite documents as for the list documents. He fulfilled all the conditions. In para 7, 6 and 7, I have scribed, I became L1. The result, day after selection, the OP number 1 remained absent for a week. And I wrote a letter to know about the result on 6/8/24, which was not answered. Again, I wrote on 7/8/24, the answer was given that L4 has been selected in my place. There is a clause of negotiation, if at all. My lords, page 41, 42, 41, 42. It was given to Ma Santoshi Enterprises.
Opposite party number 1.
DFO, Kalahandi South Division.
There must be a person. You are alleging malafide against him.
Well,
you are alleging malafide against him. That he remained absent from the office. So DFO, the office was there. The person was absent.
No. To office I wrote to know about the outcome of the bid process.
You are saying that respondent number.
I'm sorry.
The respondent number 4.
Out of.
Sorry. Which? Opposite party number 4 did not award the tender purposefully and remained absent from his office. Office was there. A person was not there.
And
you are
during that, even after joining, I wrote letter to the office. No reply was given to me. Second,
sir, you are alleging malafide against a person. You will have to implead him as a party.
No.
I'm still not able to find where you are L1. Page?
My lord, 6, page 42. 6.
42.6.
Lalu Enterprises, one button. 711.00.
42.
And whereas it has alerted to serial 2,
58.
That is letter of the petitioner. Ma'am.
'39 Annexure 2 clearly says what is the
That again is your letter. That is what I'm saying. Where is their letter showing that your rates are L1?
I could know after writing annexure. They have given letter in annexure
Page.
annexure 3. They have written letter. Neither they have quoted the amount for which tender process was. Similarly, since it is more than a crore, as per annexure 5, it is to be advertised in newspaper. No newspaper advertisement has been made in this case.
How did you know?
I participated
Ma'am, even after participation.
only from notice board advertisement. I applied for along with other bidders.
So you were the chosen few.
But Mr. Mahanti,
Ma'am.
should they not upload all these results on the website?
No, I have taken that instruction but after participation, he is challenging the tender condition.
That is
That I am submitting, ma'am.
that is
What is
additional
the
ground.
process?
Additional ground.
Ma'am.
So unless if you want to implead him, you can implead him as a party, the officer who was absent. Either you take back the ground or you press that.
If you press that ground, you have to implead him in person.
And then you may not get future contracts.
So,
Choice is yours.
in other divisions, advertisement was made and 2 lakhs more. Advertise is supposed to be made. No advertisement, nothing.
So Nanda, once you have participated, how can you challenge that this was done? You have participated.
But Millard, by virtue of negotiation, if they could settle the scope, why not me? As for decision of Apex Court and this Honorable High Court, I am supposed to for discussion. If more or less,
We are still don't know that you are L1. We are not getting any document.
There is nothing that you
so
can.
if notice,
Where is the question on?
Where have you stated in an affidavit? Have you stated your rates?
yes,
Where?
in para 6 and 7, I have stated everything.
One.
They, how many?
The website.
How are these tenders being awarded? Cannot be approved.
Almost as if it is their personal construction or
He may have to
personal work.
suffer in future, but we will issue notice.
My lord, nothing has been stated in this, my lord, because he has to.
Yes,
because he has only written 2 letters. He is enclosing.
Lead him as a party.
Whether-
Yes, the reply he has given.
Forget reply.
You have no experience. I have regarding to establish my experience. I have annexed 4.
Asked. Not
Mr.
listening.
Counsel, if you impede him as a party in person because you are in his individual capacity, because you are alleging malafide against him, then it's all right. Otherwise, we cannot accept that point. So will you?
Yes,
will you implead?
I'll implead him as a party.
So yes. Tell us what is his name?
What is his name?
Name, I'm to take instruction now. By name, I don't have any knowledge. So now he is continuing. If notice goes also, he will appear.
Who will appear?
DFO.
DFO might have been transferred to who?
No, he has not been
That you
transferred.
know.
That is information I have collected. He's continuing. Taking a leave for 7 days and settle, awarding the bid.
Who told you?
the authority DFO and
Who told you that the person is continuing?
the petitioner.
And therefore you will say whatever
No, my
he
lord.
says in the court.
This is a bid in which the labor department or other officials, if the amount is more than 2 lakhs, they have to be entered. What local committee he
The
formed?
petitioner has alleged malafide against in the writ petition against the officer who was holding the post of divisional forest officer. Which place?
Kalahandi South Division.
Kalahandi South Division, without impleading him as opposite party in his individual capacity. Full stop. By on the said ground. In such view of the matter, the allegation of malafide cannot be entertained. Stop. List this matter on 2 weeks. Stop. In the meanwhile, let an affidavit be filed. 4 weeks. Let an affidavit, a counter affidavit be filed on behalf of the opposite parties.
Sir. Well, also look. We have complied with the lordship's order, notes. People lordship kindly come to page 22 of the brief notes. There was a direction, paragraph 15.
Just a minute. Where is the order of this court?
No, sir. Well, it's order of the honorable tribunal, not a tribunal, notes.
Confirmed then.
Odisha Administrative Tribunal, page 22. That was confirmed by this honorable court, notes. Page 22, paragraph 15, notes. The punishment order dated 25/2011 under at Annex 11 read with revised punishment order dated 2/3/23 Annex B to the counter cannot stand for scrutiny is allowed and the improved order of punishment on access stands quashed. People also have given the order to our lordships.
Have you given her a copy of the order?
No,
We have recalled both the orders. Now we have requested the Accountant General of the state to pay the gratuity withheld by him, Milos.
not being paid.
Just a minute. Where is the direction for payment of gratuity?
No, there is no direction as such.
No, no, Your
But
Lordship.
one letter-
What was withheld from the gratuity amount was that amount which was shown as the recovery amount in the punishment order. Your Lordship may just kindly look at the punishment order.
Yeah.
Annex to 1. There are 3 punishments. The first one. 11, page 11.
Yes.
1 to 3, recovery of so and so amount. That amount
Yes.
is all that they have to pay after this annexure was quashed by both the tribunal, confirmed by the High Court, as well as in the review. So this is the amount that they have. So basically, quashing of this annexure means refund of this amount.
Pay the amount.
No, that's what I'm saying, Milos. Pension and gratuity has to be paid by the Accountant General, Milos. We are not the authority to pay that, Milos. We had requested the Accountant General to withhold that amount. That is why now we have said that you release that amount, Milos. Because we have not recovered the amount.
That's
the amount is
fine.
lying with the Milos Accountant General. So if you also grant me time, I can pursue the matter saying that release it.
You will have to ensure that the amount is paid.
Obviously, that's true.
Too much. The order, when was the order passed of the tribunal?
But tribunal was passed sometime in
High Court has confirmed in
6
21.
to
Yes.
2030.
but thereafter
We are
review
in
after review.
24.
No.
So you will have to expedite it. This is too much. the fellow is entitled for this much of amount, 3,58,530. You recovered that?
No, not recovered. That is the crux. We have not
Withheld.
recovered.
You have withheld.
We have requested the Accountant General to withhold the amount because he has been given a punishment. Now we have recalled that punishment. That is why we have requested him to pay that amount too.
That is 2011.
Yes.
It's a different matter that it was caused later by.
No, that's why I'm not saying. Auditor is paid
So
to
we will not dispose of the contempt application unless the entire amount is paid.
That's why I'm saying we'll also grant some time. We'll pursue it because
Grant
these
you
are
time.
No, it was withheld at your instance. So we have to
Exactly, sir.
ensure that it is paid.
yes. So in
And
fact,
not only that, there has been delay on your part. We can punish you for that.
I'm not saying anything else.
And
That
therefore,
is true.
So when?
2 weeks time also will pursue the accountant because he is not under our central government.
he may not be, he is under your jurisdiction. You know why? Because you can disengage accountant general from the duty which the accountant general is discharging.
That he cannot do for one case.
Huh?
Not understand.
Not from one for all right. We express displeasure over the fact that despite the tribunal's order having been confirmed by this court by an order dated 22/3/2021,
21. The last order is 20.
the
And there was a review also.
order of
Oh, that is why the delay.
the tribunal has not been carried out, in as much as the petitioner has not been paid the consequential benefits. So stop. Next, learn AGA appearing on behalf of the contemners has submitted that recently on 17/8/2024, the amount of gratuity payable to the petitioner has been sanctioned.
So has been requested to be paid to him. Amount is not in dispute. That amount is we have said him itself, so we'll pay it now. To
This
be paid to
gratuity
the-
amount. Is this gratuity amount?
Yes,
The
gratuity
amount of gratuity that the office of the accountant general has been requested to issue an authority slip for payment of gratuity which was withheld.
Withheld.
And what about increment, annual increment, everything?
No, that was
Those things have been
Stop.
taken.
And list this matter on 4 weeks within first 10 cases. Stop. The court will consider proceeding in the present contempt matter if by the next date the petitioner is not paid his entitlements.
Orders item number 13.
You're good. Yes.
There is a delay of 421 days. The very first day of admission, the writ petition was disposed of, directing the authorities to consider the case of the petitioner for regularization, with a specific finding that he is a DLR and his appointment is not irregular, and he has continued. Since he has continued for 28 years, his service should be regularized. Nobody has.
The latest postal tracking report indicates that the notice has been delivered on the respondent on 2/8/2024. In the none appears for the respondent when the matter is called. Full stop. In the interest of justice, list the case on 17/9/2024. In the meanwhile, registry shall verify if any counsel has appeared on behalf of the respondent.
Item number 14.
Item 14, there is a delay of 74 days. Here, my lord, the husband of the petitioner, he died prior to commencement of the 1981 pension rules, made applicable only in respect of the teachers of the educational institution. And by operation of rule, the rule is only applicable to the persons who retired from service after 1982. Whereas the petitioner, the husband of the petitioner, he expired 1979 prior to the commencement of the rule. However, the Honorable Court is directed to consider this case for pension. 74 days delay, my lord.
IA number 2095, sorry, IA number 8491 of 2023. The delay of how many days?
My lord, 74 days.
74 days in filing this writ appeal. Issue notice, sole respondent or there some more?
Sole respondent.
To the sole respondent on the question of limitation by registered post / speed post with AD returnable within 4 weeks, the requisites for which shall be filed by Friday. List the case, 6 weeks.
What is the issue now?
Says
My lord, issue involved the husband of the petitioner. He died prior to the commencement of the pension rule. For pension rule made for the teachers of the aided educational institution that came into that was framed in 1981, and it came into force from the appointed date by way of notification by the government from 82, and specifically amendments were carried out in 2001 and 2007 that the rule is only applicable to the teachers who retired from service after 1982.
So what is the reason given by the learned single judge?
Here, my lord, the learned single judge.
All right, we'll see later. Next.
Item 15.
Lordship, I am appearing for the respondent, Lordship. 1 to 1 week time for filing of objection, Lordship. About the delay, Lordship.
What is the delay?
415 days.
Final objection.
your name, please.
My Lord,
Your name, have you appeared?
my Lord, already appeared, Lordship.
Where you're Mr. Kaur?
My Lord.
All right. Mr. Kaur, Mr. J.R. Kaur, learned counsel, appearing on behalf of the respondent, raised for 10 days time to file an objection to the IA for condemnation of delay. List the case on 17/9/2024. Objection of, if any, shall be filed before the said date after serving copy on the learned counsel, on the learned state council.
Item number 16.
16. Someone has appeared the 112 days delay.
I'm appearing for the respondent, my lords. Abhishek Barik, my lords.
Abhishek Barik, okay. Abhishek Barik is the respondent.
My lord.
We can control the delay.
We are controlling the delay.
Yes.
There is a delay of, this IA has been filed for controlling the delay of 112 days.
My lord.
112 days in filing the, this is Abhishek file. 112 days in filing the writ appeal. We have heard learned counsel for the appellant and the rest, and you are Mr. Samantray.
No, my lords. Siddharth Gautam Das.
Mr. Siddharth Gautam Das, appearing on behalf of the respondent. We are satisfied that the delay in filing the writ appeal should be condoned in the interest of justice, full stop. Accordingly, we allow the IA and condone the delay in filing the writ appeal. IA is accordingly disposed of. Have you received a copy of the writ appeal?
No, my lord.
No. Copy of the writ appeal served on learned counsel for the appellant. When? By?
By
Mr.
tomorrow.
By tomorrow.
Yeah.
List the case for fresh admission on 17/9/2024.
Item number 17.
70.
124.
I'm for the respondent.
My lord, friend is appearing for the respondent.
I'm for the respondent.
No, I'm saying same order is already.
Same or rehabilitation assistant, your lordship has fixed 17th.
Already. Same order, only thing with the Sampath Kumar Yadav.
Obliged.
Please serve a copy, Mr. Das.
I'll, sir. By tomorrow.
Item number 18.
Delay 99 days. I am for the respondent number 1.
Why are you smiling?
And I am for
All right, good that you are smiling.
You file a counter affidavit.
yes, I.
Same order, Mr. T.K. Patnaik. Have you received a copy of the writ appeal?
No, I will solve it.
This also will come up on 17th.
My lord.
Item number 19.
19, your lordship. I'm for the respondent in the first case and for the appellant in the second case, your lordship. There is a delay in the second.
I am appealing to the first case. So lordship permitted to withdraw.
You want to withdraw the writ appeal?
No, actually, in the last occasion, it was closed after hearing of the secondary. The joint director, the director of the secondary education, Bhubaneswar. Sub the purpose.
Withdraw.
This writ appeal has been filed challenging the order dated 1/5/2024, passed on WPC number 10577 of 2015 by a learned single judge of this court. A memo has been filed on behalf of the appellant stating that pursuant to the said order, that since the order passed in WPC number 10577 of 2015 has been implemented, the appeal has been rendered infructuous, for which the writ appeal may be permitted to be withdrawn. Considering the developments which have taken place in the meanwhile and the memo filed by the appellant on behalf of the appellant, the writ appeal is dismissed as infructuous.
Your lordship, in the second case, your lordship, there's a delay of 60 days, your lordship.
So that also is the same thing. If the hearing has been closed and it's posted for judgment, that also is infructuous.
No, your lordship, we're challenging a part of that order. Only we are not challenging the entire order, we're challenging only a small part of the order, portion of the order.
Order is implemented. Order is implemented.
Exactly. So what are you challenging?
And I'll seek instruction, your lordship, kindly be taken any other date.
No, where is Mr. Lenka?
Mr. Lenka is not available today, he's gone out of station, your lordship. I'll just take instruction and
Tomorrow.
yeah, tomorrow.
Tomorrow, writ appeal 1849 of 2000, maybe day after tomorrow. Writ appeal WA 1849 of 2024, challenging the said, the same impugned judgment has been withdrawn on basis of a memo filed by learned counsel for the appellant stating that the order has been given effect to. Full stop. Mr. What is your name, please?
Lakshmikant Tripathi, your lordship.
Mr. Lakshmikant Tripathi, learned counsel, prays for a short adjournment in order to obtain instructions. List the case on 4/9/2024.
Obliged.
The order passed in WA 1849 of 2024 may be placed in this brief.
Obliged.
Item number 20.
Item 20, if you lordship kindly look at order dated 19/9/2024. 19/9.
99 is yet to come.
99.
I'm sorry, 19/6. Extremely sorry. I'm sorry, my lord. 19/6. But what happened, my lord, the Honorable Court directed me to implead the participants whose price bid has been opened in the meantime, but no final decision to be taken. So since the price bid has been opened, keeping in view of the Afcon Infrastructure Limited case, the Honorable Court said that you implead them as parties. So that application is filed, which is at flag E. IA number 8177 of 2024.
For impleadment.
Oh, the order was after you implead, the matter will be listed. So that is why it has not been.
What has been challenged, my lords, here is a cancellation. So if your lordships would see the first order which was passed by this honorable court.
So that was
on 22/2/2024. First, this court passed an order, it shall be all subject to outcome. Thereafter, my lords, another IA was filed on 21/3. That IA is still pending. Then third time another IA was filed, and then the court passed another order staying the further process.
No final decision to be taken.
Now, my lords, so far as the petitioner, the reason was that the petitioner himself has also participated in this tender.
Right.
First round, petitioner succeeded. Second round, he himself has participated. So the question of waiver would come, my lords, as my turn comes, because without taking leave, he has participated. Now, this is an important tender pertaining
No, but today it has come for what?
So orders
we have filed an application for
for
vacation.
completion of parties.
So we can.
And you also have a IA for vacation of
For
interest
vacation
order.
because
That counter has also been filed. But your lordship will hear the matter, my lord. We are ready in the hearing matter. But only thing is, since the Honorable Court directed for impleading the party, so I have filed an application for impletion.
Impleadment of?
Parties, my lord, those persons whose price bid has been opened.
Whether they have appeared.
No, they have no. I have filed the application. No order has been passed.
Let's see, because of the impleadment application, they will have to be impleaded, then notices will go. Everything.
So all that I pray, my lord, is that the first order be there, because my lord's order was clear that it shall be subject to outcome.
No, but subsequently, the Honorable Court heard the matter and passed the order. No final decision to be taken. There also, there is no a direction that to open the price bid, but still when they opened the price bid.
There was no direction for opening the price
No,
bid.
no specific direction for opening the price bid.
No, but can't they open the price bid without
Therefore,
direction of
Honorable
this
said
court?
no final decision taken. Therefore, they opened it. So
Oh.
I don't have any grievance on that. Once they opened it, so Honorable Court said you implement them as parties, those persons who participated.
No. My lords, para 5, there's a clear direction to open also. But
You
para
submitted
5
that.
on 6/5/2000.
So I know I don't have grievance on that.
So we have not violated any of the orders of
No,
the
I have never said that you have violated.
Price bid is
Never my submission. Order date 6/5 is there. 6/5/2024.
If the petitioner has already participated in the process of tender without prejudice to its rights.
The best course will be, your lordship remembers the other matter, your lordship directed two steps on mail IT. On mail IT. So I can take it so that within 3-4 days it can be completed. If they choose to participate, let them participate. Otherwise, the matter will be taken for hearing. Now counter agenda, everything is filed.
File, but order has been passed for implement in 19/6.
Yes, my lord, I have filed the application immediately, 25/6. That was filed on 25/6.
Okay.
It was before Justice Sadangi. I don't know, thereafter it has not been listed.
How many persons are there to be impleaded?
So 4, I think. My application is there. I've given the address also.
And what is the work?
Work is a treatment system under zero liquid discharge system and operation maintenance of Rourkela steel plant.
So this is a case where I was selected. I was L1. There was no impediment for my selection. That's the after consideration. They discarded me because there was a debarment of Delhi Jal Board. So the Honorable Court heard the writ application. The writ application was allowed. The order of not accepting me was set aside. Court directed to consider and give it. They did not pass. The next day, they passed a fresh tender.
Fresh tender notice,
Yes.
that you challenge.
Yes, I challenge that. And this Honorable Court passed an order subject to result.
On the
Thereafter,
first day.
the Honorable Court said, no final decision to be taken.
Notices will have to go. And what about the interim order?
If they give email ID, they
Where
must
is
have
the
given
interim
to
order?
them. I can
Interim
take,
order is passed on 19/6.
Interim order is nothing.
So thereafter,
As we speak today, my lords,
19/6
the
last.
petitioner now is L5 in this
Okay.
tender.
so once the price bid is open, my price bid is known. So now those persons who participated in the earlier tender, they were higher to me. Same tender. But now the price should go up. Now what they have done, they have lowered their price. So there's a question to be argued, but I'll argue that.
No, but the main, no, that I am seeing,
Last.
there is no,
Therefore, it is open to the opposite parties, proceed with the bid process, but the tender may not be finalized. 19/6 to 2024.
no. there
Initially,
also
when your
declared-
lordships your lordships made it subject to result, and thereafter this interim order has been passed. First order, if your lordships would see, of this court,
No, at that time, it was not considered. Honorable Court said,
your lordships had also granted.
at that time also, the fresh tender was not issued.
21, no. My lords, after issuance of the fresh tender, only my lord
No, no,
senior
I
has
mean
come
to
to
say
court.
that it was not opened.
21/2/2024, the first interim order, when your lordships entertained the writ petition, it was subject to outcome. Thereafter, during the hearing, they filed two IAs, reiterating the same prayer in the first IA.
No,
So,
but the only question is that whether they will appear or not. If we issue notice,
Right.
so this is also an important work.
I bow down to that because ultimately they have, since there
Is an order, the
And this was at the time of hearing, my lord. This was at the time of hearing. The Honorable Court said, no, you implead them as parties. And he raised objection. He said, it cannot be heard without their presence.
How are you blaming? He was taking his stand. You could have said that. they not. You also agreed.
I said, yes, I bow down, my lord. Your lordship said,
No, you should not bow down every time. You are not required to bow down.
It is a matter of
You make
10,
so
15
many
days.
observations.
For a matter of 10, 15 days, I can take immediate steps
All
by
right,
tomorrow.
let us see.
And on speed post or anything, so that within a week it can be served.
Well, it's not opening. Which is the IA? Okay, IA 8177 of 2024.
My lord, 8177.
This IA has been filed pursuant to order dated 19/5. What is that order?
19/6.
19/6.
So 19/6.
Pursuant to order dated 19/6, 2024 for impleading. This is like how many pages?
7.
For impleading the bidders who have participated in the tender process as opposite parties number 4 to 10 as per the details provided in the schedule below. Issue notice.
Complete first.
The prayer for impleadment is allowed. The 1, 2, 3, 4, 5, 6. The bidders who have participated in the bidding process and have been and the details are indicated in the schedule are impleaded as opposite parties number 4 to 10.
4 to 10.
4 to 10 in the writ application. Consolidated cause title shall be filed by day after, by day after tomorrow, along with, will be, implemented opposite party number 4 to 10, issue notice, writ petition, issue notice to the newly added opposite parties 4 to 10 in the writ petition as well as in the interim application, requisites for which shall be filed, requisites for issue of notice
By day
by
after tomorrow?
speed post.
By
Sorry.
day after tomorrow?
By speed post or registered post. They belong to which
Anything
place?
you don't have direct minutes.
Which will be faster, Mr.
Speed post will be faster. I
Post,
think.
all these are speed
No,
post.
speed post
By
tracking
speed
report can
post,
be filed.
requisites for which shall be filed by 4/9/2024. Notice shall be issued, making it returnable within 2 weeks. This is the case on 23/9/2024.
Just a minute. Come to the this respondent opposite party number 5.
One is in Kuala Lumpur and another one, there's one in UAE.
And that has
9.
that is why Mr. Mishra was diplomatically suggesting.
Therefore, I said in the email ID which was given to them.
Supply email ID you will see.
Then let it come day after tomorrow. I'll
Alright.
try to
If I
supply
give the email ID, that can be immediately.
That is why you're saying email ID
I first
without saying
submitted
why.
my lordship.
Without saying why.
The mail ID, if they give immediately, can be.
Yes.
Otherwise, go by courier to Kuala
This
Lumpur.
matter on
4
Wednesday. Wednesday.
4/9/2024.
So enable impleadment का कर
Implemented का रहेगा, issue notice का रहेगा.
The day after tomorrow, same order can pass with
Yes.
the mail ID they can give, I can immediately text it.
You have to dictate again, so let that order.
Subject to, of course, this is slightly out of the box. L1 is OP number 4.
Okay,
There's only, the prices have now come out. L1 is OP number 4.
okay.
So the only person who would be affected would be L1. So if your lordship can,
If says I can.
no, we have given it on affidavit. It's already there in the record. So the only person who would be affected would be L1. That is OP number 4, FI, infra and research. So if your lordships can restrict it to that, then
Your lordship may indicate for the time being.
Yes, implemented is opposite parties, but for the timing, issue notice to
OP number 4.
OP number to
FI, infra,
All are
OP
made
number
parties.
FA so and
So the
so.
notice to OP number
So
4.
what that order remain, let it remain. Newly added opposite party number 4 by speed post. That same order stands. All right. Interim order to
Day after tomorrow.
yes, requisites by day after tomorrow. And in the meanwhile, you collect the email IDs in case it is necessary.
If you can give it also, I can do that. And interim order to continue.
Till the next date. Yes.
Grateful, Lord.
But may I
23rd,
request
your
that
lordship is listing it.
since your lordship, this is a tender of higher value, can it be at a specified time?
But
That date.
Well, let it come
23rd at 2 o'clock.
23rd at no, on 23rd, you just let us know. If it is not
Yes,
taken up on 23rd, we will fix it.
sufficient, all that you mentioned. Then.
That's great.
Grateful to your lordship.
Item number 21.
Agriculture. Correct.
For that deputy director and director. Others, I think, that matters.
Yes.
This is that matter where the petitioners before the honorable single judge, they have been awarded with 5 lakhs each, and we have in the process lost the job. So that operative portion is there in 2 pages.
So which order should be set aside? Which part?
Both the parts, because we are affected by paying 5 lakhs. We are only concerned with our jobs which
And
we
you
have
are
been
not
working.
affected by their removal. So far as removal is concerned.
All have come, my lord. All are before your lordship, my lord. The petitioner, the opposite party before the honorable single judge, all have before your lordships now, challenging the very same order.
All right, we can take up the matter tomorrow. It will take some time. In fact, this has to be resolved.
Yes, ma'am. Tomorrow or day after tomorrow at 2 p.m. so that it will take some time, my lord.
But come out with some suggestions also.
In fact, what we were, my mandate is clear. We only want to save our jobs. We have been
We
working.
understand that. You want to save your job, they want you to be removed,
They want job.
they want job.
I don't know whether my senior wants us to be removed. State doesn't want us to be removed.
No, state doesn't know what do they want. Because they are agreed by only this thing,
5
payment of 5 lakh. This is what he is saying. So you remain or don't remain there.
Well, there are two categories of persons who are affected. In one case, the state has been saddled with this cost of 5 lakhs to be paid to each of the persons. In the other case, that has also already been dispensed with by the learned single judge, saying that the petitioner who has challenged that order, they themselves have participated in the selection process, and having found to be of less merit in comparison to the person who are selected, they are ineligible to get that quantum of 5 lakhs,
Right.
which has been determined in the other cases.
Right.
So there are 3 types of cases.
There is no gainer.
Only 5 lakhs, some gain only, that much only, monetarily some gain.
That is in respect of Bolangir district, and for Keonjhar district, they have said not a single pie to be paid because the petitioners have already participated, and on merit they have come low.
There the logic is correct.
But the ones who have been paid 5 lakhs, with that same logic, they also should not get the 5 lakhs.
Because
When was the advertisement challenged?
way
At the
back
in the very beginning, or
way back in 2013.
No. After the selection process was complete or before the selection process?
After the selection process was complete,
You
before
challenged.
the appointment orders were made, they challenged our selection on the plea why there was an advertisement instead of
Observing them.
Instead of pursuing the original advertisement issued, instead of issuing a corrigendum to the first advertisement, why a fresh advertisement has been issued? That challenging that they had come before the honorable tribunal as it then was available after the selection process was over, where they themselves have participated. In respect, that is the case also in respect of Bolangir. No. But the difference of Bolangir is
on 26-27.
the difference of Bolangir is Bolangir, all the persons who challenged,
Your Lordship, they've
they were
received notices
ineligible.
for
Access to
closure
make
on eviction on 26-27, Your Lordship. They're only bothering
The notice of closures is 26.
eviction.
Tomorrow? Matter is fresh. Tomorrow to hear in.
Next week. 10th. 10th.
At least so far as I think both of us, we would agree. If your lordship was speaking of resolution, if the state, your lordship may hear the state so far as that 5 lakhs is concerned. And if my learned senior would, because now as such they are age barred, they cannot. So if they are agreeable with this 5 lakhs and if that is resolved,
you can give.
No, we cannot. State. It is a state.
You can agree on that.
No.
That's why I said we are ready.
Yeah, my lord, struggling to save our jobs.
No, you say
On 10th, we will destroy everything, man. On 10th,
No, that was never mine.
So this is what the solution. The state's problem is over.
That is why my learned said we both agree.
We both
That will be placed on 10th.
If the state agrees to pay that.
That will be placed on 10th. All the matters should be placed.
Yeah, what are the options you can say?
Yes.
This is one.
This is, of course, that's between the state and them. So if they're happy with their 5 lakhs, then maybe we can continue. We can continue.
All right.
Continue with the job.
Keep it on
10th, we will take up the matter on 10th.
Yes.
See, there are two aspects. In no case we are going to deviate from the legal position, whatever may be the consequence.
Yes,
Irrespective of.
yes, ma'am.
Within the legal framework, we shall try to find out some solution if we can find. Otherwise, we will decide.
Okay.
Yes.
This way or that.
First,
Yes,
item,
ma'am. Yes, ma'am.
So far as we are concerned, legal aspect will address your assets and that is.
No, that will disclose everything. Yes. Yes.
Interim order to continue.
2 p.m.
Interim order to continue.
Interim orders are continuing.
Item number 22.
Yes.
But this case, my lord, I have already filed a note of submission also. It's a matter relating to tender. In fact, my lord, all the bid cases, there was one bid for 5 different works I have applied for. And I was also my technical bid was accepted, finance bid was open, and I was declared L1. But at that juncture, instead of awarding the work order in my favor, the additional chief engineer, who has no authority in this issue, he has called for the files and passed an order that no, you have not submitted. That order was passed that I have not submitted the document, required document. But in fact, whatever the document he has pointed out, that was duly submitted through the assistant executive engineer before whom I was asked to perform my job. And subsequently, the work was awarded in favor of the opinion number 4 and 5. That is why all these cases.
4 and 5 or 5 and 6?
Sorry, 5 and 6, sorry. And I have filed because there is a voluminous document, I have also filed a rejoinder stating entirely how these opinion number 4, 5 and 6, they are ineligible at the outset. I have filed the objection before the authorities also. In what way they have produced fraudulent documents. Even if they are ineligible to apply for the the work.
Post you cannot get over. All right.
Well, so they have been favored with the work. That is why the dispute is. It's a voluminous document. Can it be tomorrow, my lord, so that we can place.
Pending till 1 year.
Tomorrow will take. Tomorrow will take.
Mine.
As a question.
Item 23.
There was an interim order, my lord.
Hello. Interim order not extended after 1/3/2023.
The interim order has not been extended. We'll take up tomorrow. So same thing. The extension order is not there.
I have told everything in the bona fide belief that it is extended.
Number of dates.
Yes.
After 1/3/23 it has not been extended.
It's hypertechnical. Tomorrow.
23.
Your Lordship, this
Great.
is a long matter. It'll take some time. We will come on 17th, Your Lordship, at 2 p.m.
How do you presume that we can't understand long matters?
Your Lordships, I presume that I may not be able to explain Your Lordships in short.
All right, but still, what is the matter about?
Your Lordship, this is a mining matter, Your Lordships.
Mining. All right. When do you want?
17th, Your Lordships, if you can come at 2 p.m.
As requested on behalf of the petitioner, is this matter on 17th?
2 p.m, Your Lordships. Both of
2
us
p.m.
agree.
we can't. 2 p.m. 17th, you make a mention. When the matter is listed and is not taken up, then you make a mention. We can think of fixing
Your
time.
Lordships.
Item number 24.
Item number 24, my lords, I'm waiting for the petitioner in the first writ application. My lords, I'll be filing my rejoinder in 2 days. Lord, should we take this matter on Monday?
My lord, I am in 24.123, my lord. And the issue is whether the state government is authorized to invoke section 21(5) after 10 years on the basis of one judgment rendered by the Supreme Court. Judgment comes in 2017, demand is being raised from 2000, 2001 onwards. Meanwhile, Parliament has also intervened, my lord, and one explanatory amendment has come. So it will take, my lord, 10-15 days time, my lord may fix any day. We are on the same issue that whether that judgment should apply to us. I am a graphite mineral.
Mine is a quartz and quartzite.
quartzite.
Both are minor minerals, my lord.
So why will the judgment not apply?
Lord, because judgment is only for based on CEC report and that examined only iron and magnesium. In fact, in that judgment itself, when there was one bauxite mine that was excluded by CEC saying that this is not within the remit of this proceeding. And on the basis of judgment, number of PSU have been vested with the huge liability. Coal India, the state government of Orissa has issued 11,000 crore demand.
So that is material.
So no, that is material because the parliament has intervened because of that.
Different.
Yes, that is
different.
so we are taking advantage of that intervention also, my lord.
All right. Yes.
It's not. In fact, Indian Rare Earth, which is a government of India atomic PSU, my lord, that is also put some very huge demand and they are before my lord. That order is also there, my lord. My lord, we have it on 30th, if, my lord, if possible. And meanwhile, we will file some synopsis of argument.
Indian rare earth, is it listed today? No.
Not listed today. I found out when I was researching for this matter.
But it's pending before this court.
Yes, yes. In fact, what happened, my lord, in Mahanadi coalfield, when that 11,000 crore demand was raised, they went to Revisional Authority. Revisional Authority remanded matter to state government. Now, state government approaches High Court. High Court rejected writ petition. They went to SLP.
High Court filed writ petition.
Yes.
Sorry.
State filed writ petition against revision. Yes. That was rejected on saying that you have to first decide because matter was remanded by the RA. So they went to SLP. SLP is dismissed on the ground of delay. That matter is somewhere
How
in the
state government can file a writ petition?
Telling the order of the
order of the Revisional Authority.
Revisional Authority.
They can file, my lord. There is one judgment. There was earlier judgment by Justice Sujata Manohar. They can't file. Later on, it was clarified they can file because that's a quasi-judicial authority and they are party there.
Yes.
So 30th, my lord, if possible. My lord, is because my lord is holding only Monday.
We can take up if there is no interim order.
There is interim order. My lord, we can take tomorrow.
My lord, I pray for Monday because I have to file my rejoinder. I am appearing in the first writ. So I'm praying for Monday. I'll file my rejoinder in 2 days. This matter can be taken up for hearing.
Monday, not Monday.
Any date
Take it
next
up on
week.
Wednesday.
Wednesday, my lord.
7.
My lord, tomorrow I am here. So
So
tomorrow,
I have to file my rejoinder.
Tomorrow you can join online.
tomorrow I am here, my lord.
No. Whenever, wherever are you?
Lord,
You can join online.
Wednesday.
Next week.
Next week. No, not tomorrow. Next Wednesday.
Next Wednesday.
11.
Next 11th. 11th. Yeah, 11th times.
Next Wednesday.
Yes, my lord.
We are not in hurry.
Oh, I thought, my lord.
Only because there is an interim order, therefore
Yes.
we have anxiety.
In fact, it's a very important issue. My lord will decide as a principle
I'll
of
be
law.
happy to decide.
Yes,
So since all of you are there, with your assistance, we can decide.
deeply.
But Ms. Rao, please
Meanwhile,
file the rejoinder.
I will file it, my lord. It's almost ready. I'll file
Meanwhile,
it.
can I file not?
You time last time.
Meanwhile, can I file not more than 3 pages synopsis, my lord?
Please do it. Please
and
do.
list of reference judgments which I am
Please do it.
deeply
That will be nice.
deeply
Grateful, my lord. Interim order to continue.
interim order. Deeply.
25.
2 p.m.
Yeah, please, my lord. Here in the 3-4 cases are there. In one case, I am appearing. In 3 cases, my friend is appearing. In some other case, Mr. B.S. Tripathi is appearing. And all these appeals arise out of a judgment rendered by the Honorable Single Judge, wherein the Honorable Single Judge has held that Christ College is
Which order you have challenged?
Sorry, my lord.
Which order you have challenged in your appeal?
Yes, my lord. If your lordship is taking up my case is
WA 102 who is appearing?
102 I am appearing, my lord. The order, the judgment is updated 26/4/23. It annexed to 4.
First in?
Common judgment, I think.
Yes, common
Yes,
judgment.
judgment.
Page 140.
And the order in review petition?
Review, my lord, yes, the review is at annex 5, that is page 175.
Let us see, the order is 11/9/2000, oh, sorry,
No,
Review is 1412,
14/12.
review order.
yes.
no.
1412,
Original
the review,
26.
main order 26/4/23.
Page,
So you have challenged review order also?
Yes, my lord, because on the premises, madam, may kindly have a glance to page number 10. I've quoted one order.
Hmm.
When the matter was heard and order was resolved. Page 10 of the brief, sorry, appealment.
Page 10,
Page 10, I've quoted that order, small order.
first case.
Last case.
Yes, yes, ma'am. My lord is holding order 2. All these cases were heard 22/3/23. What was the order? I'm reading out, madam. All these cases. This matter is taken up through hybrid mode. This batch of cases were heard and kept reserved for judgment. However, on mention being made by Ms. Pamirath, Land Council, appearing for the opposite part number 4 in WPC 10414 of 21, that she had not participated in the hearing because of non-mentioning of her name in the cause list, the matter is listed today. Heard Mrs. Pamirath and Mr. Askedas, Mr. K.K. Swai, again on the point of status of the institution. This was the issue actually heard.
Yes.
Order is resolved. Ms. Roth files counter affidavit after serving copy of on the other side. The same is kept in record. Hearing is concluded and judgment resolved. My lord, only this paragraph 3, actually this matter was heard with regard to status of that particular institution, Christ College, whether it is a minority institution or a general aided college. That was the issue heard. Thereafter, the issue was to be heard. This was the issue. But single judge decided the matter at page 140 on merit of the case without considering this. This was the point, my lord, we have filed the review. Because actually it was heard on this issue. We have not placed the matter on review. So this can be. But the honorable single judge has held, no. I have decided on merit.
You mean to say you were not heard on merit?
Not merit. Because all the we have filed a memo also at the time of review. We have filed a memo that this was only hard on this question. Maybe order may be hard on merit of the case. Because the only issue is, my lord knows, my lord Justice Rath knows, there are 2 colleges in Cuttack city. One is Christ College and another is Stuart Science College. In respect of Stuart Science College, there was an issue. Before this honorable court, the judgment is there, my lord, on record. We have given it. In that case also, this same issue, whether Stuart Science College is a minority institution or a normal aided institution, because they are receiving aid also. But aid, my lord, there are 2 principles in state of Odisha. It's a normal aid under the Odisha Education Act and the rules framed under, they have to get direct payment. For this rule, the section 2 of the Odisha Education Act provides. For the minority institution, this act doesn't provide. And it does not apply. So therefore, there is a separate, only a government resolution to make some payment towards aid of the staff of the institution. So in that particular institution, my lord, this dispute, some dispute come with regard to appointment of principal, and that there the honorable court has held after that the Central Act 2004 came into existence with regard to declaration of the institution with regard to minority status. That commission was established. The honorable court, division bench of this honorable court had, unless whatever may be your status, because there is no clear position in this issue, whatever the position, you must approach the authority, commission, I mean, and get a certificate that it is a minority institution, declaration. Only that certificate is there with you. That institution went to that institution and got a certificate. But so far, this particular institution, Christ College is concerned. So the name is Christ, my lord, but maybe. But this was also to be obtained a certificate. In fact, my lord, on record also we have filed. They have moved during pendency of this particular case, they filed a miscellaneous application before the commission. And that document also I filed on record. They are also, as my information goes, my lord, till that they have not got still decided of this case, they did obtain a certificate. What they have shown to this honorable court is a letter of a commission in an earlier occasion where they said the commission has endorsed a government order that yes, government has declared it, accepted this institution a minority institution. That is what they say. Since the government has accepted, we are not to pass any order. And that document became the genesis for declaring this institution a minority institution. But the fact remains on record. This institution has received grantinate from the government, granted the UGC scale up from the government, and moreover, my lord, the governing body of this institution was approved under the Odisha Education Act, which the governing body didn't dispute. That approval order is there. So in one hand, they will say for management, we are the minority. And in the other hand, they will say, we will accept gratuity from you under the Odisha Education Act, and we will accept the approval of the governing body. Not once, my lord, that is thrice or many times, many occasions, the governing body has been approved by the government under the Odisha Management Rule 1991. There is a procedure, my lord, how to constitute a governing body of a private institution. Moreover, my lord, they have also received gratuity for this some employees under the block grant scheme. Because what the government has done in state of Odisha, initially it was direct payment. Whatever the salary is available to the government institution, that salary is paid to the aided institution.
Who are you?
Well, we are the employees.
We are the employees.
Now,
No.
proceeding
In
has.
the first case, Dr. Smita,
Smita Rao, I'm a lecturer, yes.
you are a lecturer.
My lord, a proceeding was instituted against me, and moreover, this particular, because the honorable single
So
judge.
the main controversy is as to whether Christ College
Is a minority institution or a.
no, may be minority or may not be, whether it enjoys the status of a minority institution under the law or not.
Obliged.
Maybe minority institution, the status has not
Yes,
been.
but whether you have recognized as such, that was the issue. And moreover, my lord, the honorable court has gone beyond why we are insisting on merit. Yes, my lord, have a.
Yes.
An individual dispute is.
Individual may have service condition.
That-
Now, my lord, the honorable court has held, because it's a minority institution, your service condition will not be decided by this court. My lord, then where will we go? We are receiving granted. But can it be tomorrow?
I bow down your lordship.
Taking follow-up action against those
I
persons.
bow down your lordship. Tomorrow, tomorrow, Mr. Das will not be present. Cannot be present due to personal difficulty.
Which Mr. Das?
Appearing for the opposite parties. For
Which
the
Mr. Das?
SK Das. SK Das. Sushant Kumar.
I am also Das.
I'm sorry, your lordship. Mr. Sushant Das will not be available tomorrow. Lordship next week.
Day is he available?
No, lordship. So
Tomorrow we'll see.
tomorrow
Let
is
it
not.
Let us come, let us we complete. My lord.
We will see.
Well,
Grateful.